Ladies and gentlemen, is it working? Can you hear me? Good. Ladies and gentlemen, welcome. It is our pleasure to entertain you after the lunch with this breakout session. There will be in cross-border data flows. Now, first, I was asked to do some housekeeping. I remember what was the first thing. The second thing was that you can raise your questions, you can ask your questions through this system. I just installed the application. It looks like it works. I don't know where this data is going, like whether it's run in the United States or elsewhere. But it seems that it works, so you can use this application to send questions. And I have here in front of me a portable device that I should see these questions on. Yes, second, I remember what was the first question, what was the first task. After we finish, there will be wrap-up session downstairs in the plenary hall. So you shouldn't go home, you should go downstairs, and there will be the wrap-up. And that was pretty much it. Good. Excellent. So now we can start with this breakout session. And as I said, our main topic are cross-border data flows. And we will discuss it with stakeholders from different perspectives. And there is a big amount of stakeholders because everybody's interested in this. This question pretty much defines the present and to a very large extent the future of information society, not just in Europe, but also elsewhere. And even in the Czech Republic, now the Center of Excellence that we have here, we ran a study to find out what we have in terms of research in AI, and there is a map. And I hope that in some of these materials that you got in your folders, that there is some QR code and you can see the map of institutions that are engaging in AI research and development. And that was surprising to find out like how many institutions are here, even only in the Czech Republic, that we Czechs still consider like a small country. So there is a big amount of stakeholders and variety of stakeholders, and I'm very happy that this panel can be composed of representatives of different stakeholders. And I will do this introduction round, and I will ask you not to introduce yourself because everybody knows who you are, but rather to say something what you think as the biggest challenge in cross-border data flows. I got this question in the morning. We had this panel discussion, and I couldn't answer it. Like, what is the biggest challenge? So, but now I'm in the other position. I can ask the question. So I would be interested in what you personally consider the biggest challenge, and we will take it from there. And I will start, well, probably as we sit, and I should read the functions correctly, with Joanna Szychowska, and she's from the European Commission, and she's the director of Trade B, which is the director, which is one of the general directorates of the European Commission. I was asking what B means, and it is just a letter. It's A, B, C, D. Closer, like that. Okay, good then. So. Joanna is from the European Commission, and she specifically stressed when we met that she is a trade person. She's not a security person or home security person or public security or whatever, or resilience, that she is on the trade side. So I would expect that probably if you would be to identify the biggest challenge, that it would be like the challenge that arises from a lack of cross-border data flows and too much protectionism. Is that right? That's right.
Sorry, I was wondering whether I should use your mic or this one. So
I had COVID 2 weeks ago, so I should.
And I'm vaccinated 3 times, so I think it's okay. So first of all, good afternoon, everyone. Thank you very much, Radim, for the introduction, and I also would like to thank very much the Czech presidency for organizing this event, or the series of events, including on data. I think it's a very useful debate, very timely, and I'll be very pleased to contribute it from the trade perspective, as Radim said. And when I said trade, it's not because there's a different perspective when my colleagues from DG Connect or DG Just talk. They just look at it from either regulatory side or indeed safety side, but I believe as the Commission we have pretty much one approach to data flows. And now you mentioned resilience. I think actually resilience is pretty much about trade, or trade is about resilience. So I might come back to it in my comments, but well, you said that it was a very difficult question asked this morning. What is it that is single biggest obstacle? I don't think this question got any easier now in the afternoon, and I suppose there are many versions of the answers possible to that one. I will offer you one, and this is pretty safe bet to say that when you look at regulatory activity across the world, because really this is a world activity, when you look at attempts to regulate data flows, well, digital trade, let's start with digital trade, because data flows is an element of broader discussion about digital trade. We all understand how important digital trade is, actually digital economy. I don't even think we should be talking anymore about just digital trade. We should be talking about digital economy. So if we all agree, and I guess we do, how important digitalizing of economy is, that means that flawless data flows across the borders are pretty critical to attain this objective. So coming back to what I started with, I would say that on the one hand, lack of consistent and clear and predictable regulatory framework is a problem, but even bigger problem is possible fragmentation and race to regulate that we observe, as I said, truly across the globe. Because on the one hand, you have all the efforts that have been done by the European Commission and the EU. There are regional efforts undertaken in Indo-Pacific and growing. This is the regional focus today. And then I say it at the end, while actually I should even start with it, there are multilateral efforts going on in WTO. So everyone is trying to find the right way to regulate digital trade and flows of data. We already see how different approaches can be, whether they center on business, whether they center on human or on state. Recently more and more present. That all makes one think that not only it is a Herculean task, it's a difficult task, but as long as we do not manage to find a compromise, flow of data will continue to be a problem. And I think we all have an interest in trying to put our minds and look for what would be the best way to regulate data flows.
Thank you. It has been a challenge from the late 90s, because that was when the grounds of data economy that we have today have been laid. But now we have the other dimension with AI, and data has entirely new value in the wake of all these AI applications. And we don't even know where the development will go. But it has been some steady, how much it is? It's more than 25 years, and we still have that obstacle. And we already have some experience with data economy, because I was quite involved in the security studies and security research. There it is quite a big problem to reach some understanding across the world. In the EU, we share the same values, but then finding common language with other nations from other cultural backgrounds is very difficult, because when you say security, something else means security in Europe, something slightly else in the US, but something totally else in Russia or in China or elsewhere. And then it is difficult to find some common grounds to collaborate between the nations. But here, when we speak about trade and economy, we do have common grounds, and there's one value that everybody's interested in, and that's money. So I would expect that this could help us to find better grounds for cooperation than elsewhere. And that's why we have here Javier Lopez Gonzalez from the OECD, who is also on the economy side, on the economic side. And I have to say my ignorance was also on display, because I didn't know that the OECD has extensive agenda on data economy. So maybe before telling us what is the greatest obstacle, then maybe if you can introduce this OECD agenda, because maybe, or there's probably not as ignorant in the room as I was, but if there happens to be anybody, then to give them the message.
Thank you. I guess no pressure there. I basically, maybe I can start with something different. You mentioned that, this thing has been discussed for 25 years. I see your 25 years and I raise you 15 more. Because if you look in the internet, you'll find that transborder data flows have been discussed since the 1980s. 1982, there's actually a very interesting YouTube video, and you can watch it and you can see how the issues are exactly the same that we're discussing today, which is really fascinating. So at the OECD, we work on different areas. I'm from the trade side of the house. They've conveniently decided to put us close to each other so that we can be friends. And so I work a lot on digital trade, and the agenda there is to try to understand and feed the discussions that can enable greater benefits from digitalization, which of course includes issues related to cross-border data flows. But we have science, technology, and innovation side at the OECD as well, which does a lot of work on AI, on privacy, and on things like that. And we work together across the house to try and increase the evidence base on these issues. So we've been doing quite a lot of work, particularly myself, on mapping the evolving regulatory environment and really highlighting two big things. There's a very big uptick in regulation that either conditions the flow of data across international borders, or which mandates that data be stored in specific locations. And so while kind of that is interesting, I think in order for us to identify the challenges that this bring, it's also key to understand what different countries are doing. And when you look across this regulation, it's a bit all over the place. So we've developed this typology, and it's simplifying a very complex issue, so bear with me, but we have four key approaches that are taking place on the cross-border data flow sphere. We have one approach which is basically no approach whatsoever, and this is a whole bunch of least developed countries which currently have no data protection or no kind of regulation that enables safeguarded data flows. And the problem here is that they will need to choose a regulation soon, unless they want to forego, because countries don't want to send data to a place which is a bit like the Far West. We have a second approach, which we term at the OECD open safeguards, which is essentially the US model, or the Canada model, or the Australia model. And essentially, this is a model where the government gives indication of what needs to be done, but leaves more discretion to individual firms as to how to manage the transfer. And the other model is the EU model that we're more familiar with here, which is the GDPR model, where it's more of a government-led adequacy, and if no adequacy, standard contractual clauses or binding corporate rules. And the last model is one which is much more ad hoc, which is the China model, the India model, the Russia model, which is essentially where the government decides case-by-case basis whether a transfer can happen or not, and it tends to apply this on perhaps less ill-defined categorizations of data, like important data or critical data. Now, the reason why I provide that mapping is maybe to highlight two things, or three things. We have three problems. The first problem is Category 0, least developed countries choosing. Which one will they choose? Will they choose US, will they choose Europe, or will they choose China? And that's a very important issue if we're to have an unfragmented digital and global economy. The second problem to solve is the problem between the EU and the US, which conveniently are at either side of me, and I feel like I'm a peacekeeping mission. But no, and I mean, I joke, but and I think that that's an issue that is, we're still trying to do in terms of trying to find interoperability. And I think the third issue is, how do we deal with the Chinas, the Indias, and the Indonesias, which are approaching this in a much more intransparent way. So just to summarize, maybe for me, the two challenges are, how to balance protection and openness. But I think that in that case, the EU model and the US model do this. They just do it in a different way. So it's about trying to find bridges between them. And the second problem is precisely that. How do we bridge the different approaches? For me, those are the challenges.
Definitely, thank you. And this goes probably even further, because mentioning this GDPR, we have a lot of experience with these rules. And is it still working? Can you hear me? I think, yeah. But, oh, no, now it works. Thank you. So, there are differences in legal cultures, and this was apparent when discussing these adequacy questions related to the GDPR. that's my very personal observation, and I'm academic, I do not have any political mandate, so I can say what I want, that if we look at compliance, how compliance is tackled, then here in Europe we have some compliance duties, and we don't always are too strict in demanding like their application to the very last extent. Now, in the US, if you have compliance people within a company, then they come and say, like, this and this and this should be done. If you don't do it, then there are these extensive fines and you run into trouble or whatever. So there it is very diligent. And then we have a problem because in Europe we know that if we have some rules, then we will not always 100% enforce them. And particularly interesting is the situation in Japan. And there was this exchange between European Commission and the Japanese government when there was screenings of those laws and data protection, and what Japanese were showing was very often just recommendations. There were no legal rules. And then for us it was a strange situation because when something is recommended that nobody really pays any attention to, but in Japan the culture is different. If there is something recommended, then everybody follows. And then the obvious question from the European side was, what if the businesses do not follow this recommendation? And then the answer from the Japanese side was like, we don't have any alternative for it because this never happened. So there are very big differences in cultures. And I got here the first, I'm not writing SMSs with my son, I'm really on this Slido, and there is a very interesting question that I will add to this first question, like what you think is the biggest challenge, now to our next panelist, who is Ruth Berry, and I hope I read it correctly, Acting Deputy Assistant Secretary for International Information and Communications Policy at the US Department of State. And I would like to ask Ruth, besides what she considers the biggest obstacle, the biggest problem, also whether, the question is whether it is possible to set common standards for data transfers between US and EU. We know it is possible, definitely, but I would modify this question, if I may, like where you think that it is like easy or where you think that it is harder.
Thank you. Really glad to be here with such esteemed panelists, and thanks to the government of the Czech Republic for hosting this conference. This is an issue that I think is really foundational to how we think about governments working together in the digital age, because data flows are so fundamental. And as digital technologies touch more and more aspects of our lives, more and more data is able to be collected. And so these are really important conversations, and they're difficult. There aren't easy answers, and it's important that we have these conversations in a frank and honest way among governments, among private sector, among civil society. This really does need to be a multi-stakeholder conversation. And I think some of the biggest challenges, I will say, is really understanding what problem governments are trying to solve when they think about regulation. So is it about data sovereignty, ensuring that they have access to the data for law enforcement purposes? Is it about data security, ensuring that others do not have access to data? Is it about, this term that I hear but is not really defined, that data is the new oil? Is it about some sort of value that they hope to acquire from the data? And I think they're just really understanding what are the objectives. In the United States, as it's been pointed out, we take generally a risk-based approach to data and thinking about the class of data, the category, and that would feed into the level of protection. But different countries have different approaches. And I think interoperability is a huge challenge as we think about grappling this issue. On the point about the US and the EU, I had the great fortune of spending the last year leading negotiations on the new transatlantic data privacy framework. And I'm happy to say that I think we have reached an area where we will have adequacy between the US and Europe that will provide a durable legal basis for transatlantic data flows, whether it's through data privacy framework certifications, binding corporate rules, or SSCs, which now the acronym is suddenly escaping me for what that stands for, or SCCs. So we had an agreement in principle in March this year, and then since that time, we worked to translate the U.S. side of this agreement into an executive order, which was issued several weeks ago, and really puts in place, I would say, incredible new safeguards on signals intelligence for law enforcement and national security collection that, frankly, I will say go farther in their transparency than many countries around the world, including member states. But it also puts in place new safeguards ensuring that collection is both necessary and proportionate to advance legitimate objectives. And it also creates a two-layer redress mechanism for EU persons who feel their data may have been improperly accessed in contrary to US law. And so I'm happy to talk about this agreement and this new executive order in more detail if there are questions, but we do believe that this will form a durable legal basic for transatlantic data flows. But I think it gets to the heart of one really big issue is really the sense of trust. And I think democracies have not done a good job about highlighting the differences between government access to data in democratic nations and in authoritarian nations. And so I think really one great thing that I hope can come out of the new US-EU agreement is that we can stop, admiring our differences and really focus on our commonalities and working with other countries and other democracies around the world to really understand that there is no qualitative or quantitative equivalency in how democracies with independent judiciaries and rule of law and democratic checks and balances approach access to data compared to authoritarian governments. And so I think that's a really important conversation that needs to be had more publicly and with more countries.
Thank you. I was smiling a bit when you were speaking about this, and there's a very extensive amount of work done on this new data agreement, but we've been there already twice, and so this is like third attempt, and we are getting more and more sophisticated in that, and I think that it is extremely important what you pointed out as the last element, and we had it also in the morning, because there is fundamental cultural compatibility between US and Europe, which is a bit different ways how to pursue the values, but the values are the same. And coffee is a good example. There is espresso and Americano, and essentially it is still coffee. And there, I think, is also where we should look for differences between other parts of the world, because now the game about AI, it's US, Europe, and China. That's fundamentally this between these three. And definitely we should distinguish, and trust can be established only in a system that is based on discussion and partnership. And the other way how you can organize a state or international community is by establishing hierarchy. And this we see in China, this we see in Russia, this we see in North Korea and elsewhere, and you invest into hierarchy. But when you have hierarchy, then there is no trust, there's just fear. And this is different, what we have, and it is important that we communicate. And now, yes, we have third version of this like data exchange agreement, and we see how it goes, and maybe it will be taken down again, who knows? Anything can happen, but we are moving forward, and that's a result of discussion, not of dictatorship that somebody would say like, yes. And now you have elections in the US, and if it would be elsewhere, then we wouldn't care about it, because we think like, that's the president and that's it, and who cares about any elections? But now it is important like how these elections come out in the US, and it shows that, and we always have some elections here in Europe, here and there, and it is always important. So I think that this shows this fundamental cultural compatibility. And I have here one interesting comment, and maybe we can get back to it later on Slido, regarding EU and US, that there is some general assumption that Americans want European data, and we try to protect European data against this American, like not influence, but against Americans not seeing too much or not being going too deep into people's privacy, etc. But we can put the question also the other way around, like what about American data and European access to it? And again, it reminds me of the situation when the trade agreement with Japan was negotiated, because it was the same kind of approach, like how European data will be protected in Japan, but then the Japanese side had also a case like, but we would also like to see how Japanese data will be protected in Europe. So it's always a mutual debate, although if we look at those user-generated content services that popped up after these 1990s, all these Facebooks and Googles, etc., it is, if we would think about data like oil, then the flow is a bit like, it is a kind of one-sided in a way, but definitely it has to be mutual, and this trust, it has to be on both sides. Now, I welcome here our third panelist, Jaromír Hanzal. He is from the, I don't know how to translate it because I know only the Czech name of this, Association of Applied Research in Information Technologies.
We try to go with AVID because it's easy to say.
Okay, so that's the shortcut. But in order to indicate what it does, then it is an association of innovative IT companies or research establishments. So from your perspective, or from the perspective of your membership, like, do you see these obstacles, and where do you see them, like, at first?
First, thanks for having me here and our whole organization. It's a really great conference so far in terms of how many people are here from many different countries, including our friends from the United States. We missed you here in Europe for a few years now. So it's really good to meet everyone. I represent the industry and mostly small and medium companies or scale-up startups. So sometimes my job is to take in terms of regulation, take the complex problems and try to really distill it down to what it means to me. So very simple answers. Sometimes I'm not sure I'm really good at it, but I'll try to offer one. And you all mentioned what I think, and I would agree with most of what's been said here. And I think the term that we should use is geopolitics, because it might be of my age, but I thought like 20 years ago maybe, the overall business-driven environment helped to foster globalization, but now we see deglobalization happening, meaning like there's a French sociologist, Aron, who says it's the primacy of polities. So the polis sort of like coming back and says, I'm in charge of this, and I want to be in charge, and I want to show the others that I'm in charge. And I agree that maybe it never was like this. Maybe there always have been different cultures. So the culture of being in charge has always been here, even during that era. But when politics is not done in terms of like mutual interest, but as a competition, zero-sum game, obviously the actors are trying to protect everything they seem valuable, and then data are valuable, or will be, or everybody thinks they will be, or they carry some value not in terms of consumer policy or not in terms of doing more business, but in terms of national security. So there's always a little red line of national security in the data there, and data flows, it never will disappear. So I think in the overall competitive geopolitical competition or environment that has been up lately is the reason why there's more and more restriction on data flows. A lot of debates on how to regulate them with like-minded friends. That I think like-minded has been the most said word at this conference, and it's the only way to go. Maybe we should go in terms of looking for business opportunities, like even broader. I heard a lot of about India being involved because they're members of Quad. Also, they're able to share security information, so they might be a good ground for growing business and exchanging data among other like-minded states besides USA, Japan, Korea, etc. So I think where the question was where the obstacle is it's in politics and geopolitics and the environment. It's hard to tackle, frankly speaking.
That's an interesting idea. So far, we don't have much controversy in the panel, do we? I hope we are not going to get booed by the audience. And my personal impression is that there is not much of controversy, even like if we look at different jurisdictions, or even if you look at the debate between EU and the US, but rather inside, when security people talk to business people, and then international relations or something, then there is the controversy. So a real debate is probably between these agendas. But just to pick up this last thing that I read on Slido, that was also like very particular question. I would like to follow with Ruth, because Ruth was involved in these negotiations of this new privacy or this data protection regime between EU and US, and the question was whether these concerns about protection of US data were raised against the European Commission. Because also my experience was that when Privacy Shield was negotiated, there was Secretary Pritzker, and she was sieged by the demands from the European side. So if there is anything, and if you can just reveal some of the background, like where, if there are any data concerns, data protection concerns raised by the US side in these negotiations.
Yeah, it's a great question. So first, I'll say, yes, we have had 2 agreements overturned, and there is no desire, I think, on any part to see a third one. So I can say with great confidence and honesty that the European Commission and DG Justice did not go easy on the United States, and were very clear what they needed, and based on the court decision to come to an agreement that would withstand future challenge. And the United States agreed. None of us are interested in having another agreement overturned. And so we really focused on the deficiencies outlined by the Court of Justice in the Schrems II decision. And I think it's fundamentally different than the last agreement. You have officials within the Office of the Director of the National Intelligence who have binding authority over intelligence agencies in terms of directing remediation. Before, it was an official at the Department of State. And as much respect as I have for my organization, as does everyone else, there was no binding authority over the intelligence agency. You have an independent appeal mechanism through the Data Protection Review Court, which is housed at the Department of Justice, which then also has the authority to issue binding interpretations of U.S. law.
But that sounds very European.
I mean, this was developed through close negotiations with DG Justice and the EU Legal Service. So, we really sought to find a way that within our legal and constitutional system, which is different than that of Europe, that we were able to come up with essential equivalency and adequacy. So I'm very hopeful. My lawyers have advised me I'm never allowed to say that for sure it will stand up to court challenge, but we feel confident that we do have a durable legal basis. On the issue of reciprocity, in the executive order, so the safeguards apply to all signals intelligence collection globally, but the redress mechanism is only available to complaints from qualifying jurisdictions. And in order to be determined, in order for the Attorney General to issue a determination that a location is a qualifying state, there has to be a review that the laws of that jurisdiction offer both equivalent protections but also equivalent redress to U.S. persons if they feel that their data has been improperly accessed. So reciprocity is indeed a key factor in the new data privacy framework.
Thank you. That was a big thing. This reciprocity was. This is one of these big differences that we have between U.S. and EU law, because in the U.S. law, there's a long tradition of distinguishing between U.S. citizens and non-U.S. citizens when it comes to redress and various procedural rights, etc. While in Europe, this is not really working. So we have cybersecurity incident here. While in Europe, the citizenship thing or this distinction, it was not very traditional, and we were not used to it. And I think that we a bit underestimated the impact of putting EU citizens on the same level as U.S. citizens, like internally in the American politics. I can imagine it probably wasn't very difficult, and I think that we did not appreciate it properly, just because we do not have this here and we do not have this experience. Now, I should be a bit more democratic, because I just found out that on this Slido there are also likes, and I was picking questions that didn't get any likes, and those that got the most likes I've neglected. So now I will recover, but I think that we can move on with this debate. And this question that I consider highly relevant, and not just me, but also these likes, is like where this debate should take place primarily, and it is mentioned here the WTO. So my question to Joanna, like, wouldn't it be useful if we would go a bit stronger into the debate on this level, on this platform, and try to establish something like, I don't know what GATS for data or GATT for data economy or kind of platform like this, because sometimes it is easier to reach a consensus on the international field rather than at home with all the political problems and troubles and elections going there and back. So what do you think?
Well,
Yeah, of course. Well, I was first thinking about you, but definitely I would be interested in the opinion from a body that, of course, doesn't have the primary role of negotiating this on the international field. You are primarily concerned about the European single market and about our mutual relations. But I was curious what your opinion about it is.
well, I think raising problems to multilateral level has advantages and disadvantages. It's pretty much a banal statement, but I think it may help, but it may as well complicate things, because you are right. On the one hand, you are free, even though not entirely, from internal ramifications, and you are minded to look for compromise. You also feel the pressure of the parties to find such compromise. But if you look at e-commerce negotiations that have been going on for several years now, and we had a number of topics there. We have, I think, more than 40 areas where we negotiate. The progress where we have achieved so far all concerns those areas and subject matters which are relatively straightforward. Where we are still struggling, and quite fundamentally, is precisely about data flows. We have problems with source code, we have problems with customs duty, so all that is sensitive remains still unresolved and will require a lot of push and a lot of determination to find a compromise. Now, maybe a comment about US and the EU, because Ruth said that she's convinced that, first of all, we're going to find a solution to the question of privacy, and that ultimately what we are talking about here is the same objective, but reaching this objective through different means, of having different ways of looking at data flowing or not. And I think this is not where I would disagree, and I would not also minimize the problems that remain that we will have to work out. But still, if we are talking about multilateral setting and importance of digital trade, of flows of data, and we are talking about truly global solution, I think far bigger challenge will be what to make out of integrating those countries and those systems that are completely on the other scale. And you gave the example of China, you gave example of those countries that are very much state-centric, where their understanding of topics we are discussing entirely different. So if you see that there is a pretty important pressure coming on everyone to find a truly global solution, for me, the point is not where we're going to bridge halfway the solution that we have in the US or in the EU, but how we are going to include those that profess very different principles and solutions. So this is truly the dilemma, and unless we consider that the deal is not really relevant multinationally, or that we can live without WTO, I think that will remain the single biggest challenge.
Thank you. But then maybe it is also about the question of how deep can we go in development of these relations on the international field in terms of establishing trust? Because I can imagine that there could be, we already tend to forget about the previous US presidency, which didn't help much the EU-US relations, but still, I think that the debate can go a bit further in terms of trustworthy elements or trustworthy ideas, rather than if we get international, and the establishment of trust is probably more difficult, and then it probably would get to higher level in terms of geography, but to lower level in terms of sophistication and detail. But yeah, Javier, this is your task. So why don't we still have a WTO GATS in data economy?
Well, I mean, I think it's a very difficult question because it's also a loaded question because, issues of privacy and of national security are, of course, in the exception of the GATT and of the GATT. Yeah. The question is whether they appropriately reflect, what is being thought of here as trust across international borders. But perhaps I would caution with the WTO being the solution for this, precisely for what Ruth was saying earlier, that this is sort of a multi-stakeholder discussion. And this involves a whole bunch of different people in the European Commission, DG Justice, DG Connect, DG Trade, and sort of maybe the WTO as a solution to this problem would cut across that sort of wider multi-stakeholder engagement that is needed. So even as a trade person, I'm a bit cautious about that, but particularly having looked at how countries balance this sort of openness with safeguards. I mean, a lot of the approaches are unilateral in the sense of the EU's approach is an adequacy decision and it's not relevant in terms of trade in that it does not go through a trade test. But the other approach that's out there is plurilateral arrangements. These are your Convention 108, your global APEX CBPR and whatnot. Again, not necessarily a trade solution. Then you have a purely trade solution, which might be the joint statement initiative discussions. But we've seen the evidence of what can be achieved through trade via the existing agreements that are in place. We have a pretty good model of CPTPP, we've got USMCA, we've got the EU-UK Trade and Cooperation Agreement, and of course we have RCEP, which involves China, which is one of the more difficult things. So one of the things that we've seen with RCEP is that even though it enshrines the principle of cross-border data flows between countries, the exceptions are so big you could drive a truck through them, in the sense that it's a self-judging exception. So for me, the idea of a global solution is a really appealing one. The idea of having the WTO at the center of that is an interesting one, but I think that the WTO and a global solution is only possible if we make progress bilaterally, if we make progress amongst like-minded countries, and if we involve much more the different communities. Trade, at the end of the day, or trade policy doesn't tell you about the principles of national security or principles of privacy, but it does allow you to work across different areas and interoperate. And I think that we need to be very cautious that should be the role of the WTO.
We're trying hard between EU and US, this personal data protection, and sometimes some courts have a bit different opinion, but we are trying. But this WTO particularly, I think, is interesting because it is already well established, relatively powerful, and most of all that there are institutions. There's the panel, and in order to have working mechanism, and that was one of the problems of Safe Harbor and then Privacy Shield, the institutions. And Ruth mentioned that now one of great work is going into the establishment of not just mechanisms but also institutions. And that is, I think, existing on certain level with the WTO, unlike in the case of other organizations. But now my question will go to Jaromír. From the perspective of those who are really in the front line of development and deployment, these new technological solutions, if you can consider on which level of importance this debate is on different levels of international cooperation. So is it of your primary interest to unlock the real functioning of digital single market, because we do have digital single market on the paper, but in real life we have these intellectual property rights and we have different institutional approaches that makes it difficult and costly to develop compliance schemes for even handling data within the common market? Or is it more EU versus US, or more EU or anything versus anything else in the world? So what is of the biggest concern of those people who are really on the ground with their technologies?
Okay, I basically think that, speaking from our members' perspective, the company of my president, not the president of the Czech Republic, but of our association. So they hold the largest amount of data set in the world of flight searches. Whatever you have searched flights going from somewhere to somewhere, they have scraped it or got it, and they can analyze it. And it's and they're doing it on a global scale: the United States, Asia, Europe. So they have, from that perspective, experience with all the regulatory tackles in different areas, and their approach, or just a general approach of the companies, I would say, or startup companies is no, oh, how should I, comply with all the rules? It's just, let's just do it and then hope for the best a little bit. So I think there's two types of regulation within the EU. Most of the members I see, so that they're on the European market, so whatever is in the digital or common market happens. So they ask me, what do I have to do? And I would see like two types of regulation. One of them is what I can't do, shouldn't do. I'll be punished if I do. That would be GDPR or AI Act coming. So it's something that's quite heavy on regulation. And I mean, we already see that the United States and China already invest more in AI in general. So Europe is a bit behind in that, even though we have some great cases here. But the question would be, so do we get more startups or innovation by having a regulated environment? And I'm for the regulation, not against it. But again, I think it's been said here today, I think it should be very well discussed. So that would be one frontline observation. The other ones would be very positive, like where the regulation actually creates the business opportunity. That would be, I would say, EHDS on the health data spaces. That would be super, super complicated to happen. There's a large potential in data, large potential in creating business, but that would never happen without the regulation because, I mean, it's sensitive personal data. And we would be happy to see it. So the idea is good. I'm a patient. So if I get a heart attack in Italy on a beach, I want to be treated in line with my previous ailments, not just by random whatever doctor is there, how experienced he is, because they can't exchange it. And we have seen a lot of development there in Ukraine, for example, with their DI app. So they can. There's a lot of millions of refugees that are able to approach their health data. Somewhere abroad from Ukraine because they took it to cloud. And there's no regulation on that. It's a war situation, obviously. So we should try and think how to foster more business opportunities with regulation, and that would be very welcome by the industry, I have to say. I'm not sure if I answered the question. But
yeah, it is very important that you pointed out this health data because that's probably one of the most difficult areas, but also one of the areas where there's biggest potential in Europe because there's unprecedented amount of high quality health data in Europe. And it leads me to another question that popped up on this Slido, and that is, and I can't really answer it, but so I'll turn to Ruth. Can greater transparency and accountability for data flows reduce the risks of data, or are full restrictions required in certain circumstances? I think that this question leads to the method that we can use in order to regulate. And if I remember correctly, then data protection or data privacy case that generated the highest financial sanction is not originating from from European Union, but it appeared in the United States. And there's this federal legislation. I forgot the shortcut. It's about health data and privacy in health data. And there was a case with extensive remedies. It was really bad case of some data. I think it was related to HIV patients, and then this data was somewhat released, and then it was so heavy punishment that we haven't seen anything even close to it here in Europe. And I think that the question has more general layer, like, should we go in the direction of restrictions and compliance, or should we leave it open and then just define liability titles, and which is more functioning? Because what we see is, in my opinion, especially in personal data protection, that we are getting close to each other in terms of like cooperation between EU and US. In the EU, we start to give individual rights to people and individual enforcement mechanisms. That's what GDPR is typical for. While in the US, it's not on the federal level, but some of the states, they are developing institutions and structures a bit similar to what we have in Europe, especially in California. I know that California is not entirely like US, but we see this, that it's getting a bit close to each other in these tendencies. And the question is like, which approach is better? Like to leave it open and then to strike with liability, or to impose these restrictions and compliance obligations?
It's a great question, and as a representative of the State Department focused on foreign policy, I don't know that I can be sort of prescriptive in terms of U.S. domestic policy in this space. But what I can say is that, you know, the Biden administration has called on Congress to pass federal privacy legislation, and I do understand the sort of personal right of action to be one of the key issues outstanding in the congressional debates around federal privacy legislation. But I think, you know, to come back a little bit to this idea of health data sharing and health research, I agree that this is an incredible opportunity for potential and for good to come of data when it comes to cancer moonshots and personalized gene therapies or advanced Alzheimer's research, to really use data and research to solve some of humanity's most pressing health challenges. But to do that, we have to be able to share data, and it has to be personal data, especially if you look at, for example, gene therapy. Like, that includes very personal data that cannot be fully anonymized in order to do this research. And so, but unfortunately, we're in a situation due to GDPR where our research institutes are having a very difficult time sharing data and doing research. And so I think one area that is a high priority for this administration and the State Department as we think about working with the European Union going forward is, can we resolve these barriers, whether it's a sector-specific adequacy finding or looking at other sort of potential models. As you pointed out, we have very high level of standards of protection for health data in the United States, having taken a sectoral approach. And so I think there's opportunities there for us to continue these conversations with Europe to really help us address shared challenges. And I just wanted to touch on something else we were discussing before briefly about where is the best way to have these discussions. And I think, you know, I will say I personally, you know, GDPR is very proscriptive. So it's not about what is the level of protection, but it's exactly how it has to be protected. And to me, that does not bode well for this idea of interoperability. And so not all legal systems are the same as what you have in Europe. And if there's not sort of an interoperable set of rules that enable countries to meet the protections, but in a way that is aligned with their own political and legal systems, it's going to be very difficult, even under a WTO or any other system, to have these sort of shared rules and understandings. I think the cross-border data privacy rules are something that the United States is really supporting. They came out of APEC, but we're looking to take those globally as a set of interoperable rules that countries can certify companies that says they meet a set of standard, but in a way that is can be applicable to different legal systems. And I just want to give a shout out to the OECD, because I think these evidence-based approaches really help cut through some of the mist or the fog about what are we really trying to protect and why, what are different systems, do they in fact protect data at a higher level or privacy at a higher level, what is the economic cost? These are really complicated issues, and so without a clear evidence base, it's hard to really think about how to address them. And so just want to give a shout out to the great work of the OECD in this space.
I think that you named it very correctly as the question of evidence-based versus risk-based approach. And I think that the position of the European Commission and European lawmakers is rather on the risk-based side. We are too concerned about or too afraid of waiting for the evidence. So that would probably be on the side of compliance rather than liability. Am I right, Joanna? Yeah, do you think so?
Well, I think there's maybe one more dimension that I would bring to the discussion about what really matters when setting the solutions or the laws, because there is a question of evidence, but there is also a matter of what is the nature of certain rules in the societal and constitutional framework of the EU. And I think this is yet a very different discussion, but this is something that will not escape when we talk about data flows in the European Union. Whether we like it or not, privacy has a certain value that is much more protected than any other fundamental rights. One may ask a justified question, why would you say that about privacy, why not about any other rights? And I think this is a fair question. But that doesn't change the fact that we put privacy above many other rights. And that frames our way of thinking and doing discussions and negotiating this area with whoever we are talking to. So maybe Referring to what Javier said, and I was wondering how actually you see this notion of having bilateral agreements before we go to the multilateral platform, I think looking at it from our perspective, there might be two reasons for going this way. One is because indeed once you manage to strike understanding and find a solution with bilaterally, that will create certain push for finding multilateral deal, but it may also be looked at differently, meaning we do try to have a network of bilateral agreements, being aware that we might not be able to have a deal at multilateral level. So I think there is indeed a broad reflection going on, not just about how to defend your own position, our own position, but where does it take us more globally, and what is it that will be the safest solution, given that, again, we have certain constraints, and I think this is what our partners understood by now, and that doesn't discourage them from coming and talking to us. I would even go a step further, given that we have managed to find a solution with New Zealand recently, UK and Chile before, and now we are engaging in discussions with Japan, which are very keen on trying to look for this common understanding. It might as well mean that we are not that far apart, and in the end of the day, this is a matter of moving a bit in our respective positions while still respecting the red line. So I think there are a number of interpretations that can be attached to philosophy of negotiations, which still, coming back to your first point, we can't do away with the fact that privacy has certain status in the EU law, and that's what guides very much our negotiations.
Yes, and here, because the legal cultures may seem very similar to each other, because we have bilateral laws and we have contracts on both sides of the Atlantic, and they look a bit similar, but the North American law is typically driven by the methodology of pragmatism, while in Europe we have the positivist grounds, and that also defines these differences. But I wanted to ask Javier practically the same question. So if we move the debate to the international level, and we would be drafting something like an international convention on free flows of data, then which approach would be more appropriate? Well, we already heard from Ruth that it may be this like ex post approach, or these like liability driven or evidence based approach. Is it true? Or can we expect that if there is any initiative appearing on the international field, that it will be like going in that direction?
So I think that's a really difficult question. I mean, we've been engaged in these discussions at the OECD for a while, including also participating by the G20. I guess the point I want to make here is that we've talked a lot about privacy, and privacy is one of the main reasons why, you know, we sort of try and condition the flow of data, but we also have national security, intellectual property protection, digital security, and of course cross-border data flows complicate our tax policies, our competition policies, and our trade policies. So I mean, at the OECD, what we think and the way that we're trying to approach the cross-border data flow debate is via involving the different policy communities. So we have the Trade Committee, we have the Science, Technology and Innovation, the Digital Economy Policy Committee, Taxation Committee, Competition Committee altogether. And to be honest, what we're trying to do is basically lock everyone in one room, throw away the key, and see whether we can try and find a set of solutions.
But you still do not have that everybody, because then you would need to have somebody from NATO, from I don't know what, UNODC, from UNCITRAL, and from all these other like fields, and that's probably impossible.
So I completely agree with you, but you know, in this issue, let's try and make the problem smaller. Because it's a huge endeavor. So at first, one of the big problems is that these discussions are happening in policy silos. And what we need to do is make sure that we try and open up the silos. And the OECD is probably a good place to try and get these silos open, because we are a bit set up like a government. But the OECD is a limited membership organization, so it doesn't provide you with a global solution. So what I think the role of the OECD is in all of this is to enable the discussions to happen. And then those can then feed into things like the G20 discussion where we open up to the Chinas and the Indias.
But then there's immediate other question. So do you think that it's more likely that we will have an international agreement for data in particular field? I don't know what, agriculture or maybe even this health, although that's, as I said, it's probably most difficult. So do you think that it could go in this direction so that you would have to lock inside of the room only a limited a group of people rather than everybody?
So I feel I'm hogging the microphone, but let me just say one thing. I think the problem with the way that you frame the question is that you're looking for one solution, like, in The Lord of the Rings, one ring to rule them all. And I think that that's not the right way of looking at it. When we look at the evolving regulatory landscape, there are solutions that have been built in the context of the privacy discussions. At the OECD now, we're having the national security discussions about access to personal data held by the private sector. You have the trade solution as well. So what I think that we need to do is stop thinking that we will have one, key legislation that sorts everything out, and start finding solutions across the different areas of analysis. And I will sort of bring this to Jaromir as well to ask, my understanding when I talk to businesses is that they like options. They don't like just one different thing. I know that even between the EU and the US, some people will use the old privacy shield, or some people will use other types of transfers. In Singapore, they can transfer via the trade agreement. They've got contractual clauses. They're part of different APEX CBPR. So, I think that what the community and what needs to be discussed in that room is also acknowledge that different communities have different approaches, and acknowledge that we need to create a range of different instruments to enable this. Some, of course, will require, very strong sectoral approaches, like in health data, as was said earlier. But others might be relatively easier with, machine data, for instance.
Yeah, let's hand it over to Jaromir. Just my point. I also give this Singapore as an example. When we talk to our government and we tell them, like, look, we do not have something now, and in Singapore they've already have it for, I don't know what, 20 years or 15 years or even longer. But here the problem is that Singapore is not entirely a democratic rule of law state. So in terms of these values and political principles, it's also not exactly like 100% compatible with what we have here. But I think, now Javier took my job, and it's a brilliant question.
Thank you, and I'll just agree first, and I give a very example that I think is important to mention here as well, is that most of the regulation we've been talking about happens because of on the evidence-based side, what the really big companies or companies that have grown very fast have done. So that's the evidence-based approach. But it's mostly just a few really big companies that are the concern of the European regulation. But then you come up with the really big bad, like the GDPR, and then you have all these SMEs that have to comply with that, and it's not a very natural thing to do for them. And they just have to hire people just to comply if they want to go abroad. I would just like to mention that only 8% of European SMEs do business across at least one country. So most of the countries, most of the SMEs really operate within just one country. I think we should unlock the potential of these with having regulation that's easy to comply. From a certain perspective, I think what's been done on the Digital Services Act is that includes only the very big platforms and not the smaller ones. So I think the threshold is 45 million of people there. So that seems pretty reasonable thing to do. So sometimes options is good. Sometimes not include the SMEs at all in the regulation is a really good idea, I think.
Mm-hmm. And I will follow with another question. I have to ask this question because it got most likes. And it's about whether limitations to data flows may mean that companies do not have access to these solutions offered by top companies. Probably I would understand the question in a way that do these barriers in data flow prevent you from working with technically advanced solutions that are not available because of these barriers? And so the first question is, well, this is an assumption, but I would rather have it as a question. Like, do you feel it as an obstacle, these barriers to data flows that prevents your members from working with these truly high-tech partners outside? Or do you have any case that you can mention where you are limited in, like, I would like to do something high-tech and I have a partner here on the other side of the ocean? And this prevents me from working together on something.
I can't come up with something like that from the top of my head, but I would like to mention something else. So one of our members, I'll go back to health. So they collect, say they do heavy psychiatric diagnosis, so they collect some data on behavioral changes. So you would wear a device and that would send some data, analyze it, and put it to a doctor who said, raise your medication or something like that. They have done quite a lot of research here in the Czech Republic. And when they wanted to grow a bit, so they wanted to go to Germany. And the first thing they heard is, maybe you have a German company, it will be better for da-da-da-da-da. So now they're not a Czech startup anymore, that they're a German company with a Czech branch, because it was much easier for them to do, and I mean, it's for the clinical studies as well. So this is an obstacle that all of our members think are faced, like the very simple ones, how to make the first steps when they're able to do it, and they sort of get in the loop. I think it's much easier for them, but the first step is the threshold here.
Thank you. I have very similar experience with one of Czech ministries, and we had a debate particularly about e-health, and then the arguments were, we can't do this and we can't do that, and the GDPR prevents us from this and that. And there were people from other member state, I can't really name them, and they said, but in our country it has been working already, and here we don't have excuse, because there's the same GDPR that applies in the Czech Republic and in Germany and in elsewhere. So I think that here might be the problems, that there are solutions available, but we are just not smart enough and not motivated enough probably to develop them. The question is whether this is just within the European Union or whether this applies to these offshore transfers. And that's probably also going back to what Ruth mentioned regarding those rules as we have designed them in the GDPR, because one important difference between the Data Protection Directive and the GDPR is that GDPR is less restrictive in terms of protection of personal data. Seriously, what couldn't be done, especially in biotechnological research, medical research, etc., what was not possible, it was happening because the rules were not enforced. But it was prohibited, and now it can be done. So it is less restrictive. So the difference is sometimes not in the law, but in the actual practice. And that is the second part of this question that got most likes, and I have to mention it. So one part was about these more advanced services and data transfer obstacles, acting as obstacles to use these advanced services. But the second part of the question, now the ladies deleted it already, but the second part was, are the data really better protected when they are being processed in the European Union? Now, that's a question.
You're looking at
Yeah, definitely. Well, whom should I look at?
I can say something about this if you want.
no contradiction.
So I think that, I think requiring data localization does not always equal greater cybersecurity, because for a number of reasons. One, companies decide where to locate data centers based on a number of factors, including ability to secure that data, latency to where their customers are, as well as, having the workforce to be able to manage that data center, et cetera, connectivity. And so requiring data localization can, one, mean that there are more points of entry into these servers. If there sort of has to be an entry point in every location, it may be harder for the company to secure. But also, and we saw this very clearly in the Ukraine situation, which had data localization requirements, and then during Russia's unprovoked invasion and aggression, they had to scramble to find a way to move their data into other locations via the cloud. And frankly, relying on US cloud companies, which are very advanced in terms of security and performance in this space. And so, data protection and data privacy data localization is not synonymous with data privacy and data security. And I think that that's a really important point to make. I would also say that it's not just about US companies locating servers in Europe. That is not what is under consideration regulation and GDPR and looking at enforcement, it's doing business with U.S. companies at all. And I think that that is something that, you know, does affect small and medium enterprises. For example, there may be a number of small and medium companies whose only online presence could be a Facebook page. Or, particularly during COVID and the move towards online, the ability to rapidly scale up your service by using cloud solutions where you sort of pay for how much you need as opposed to having to invest in data center and server capacity for your own small business. So I think it's not a zero-sum trade-off between sort of large companies and small and medium enterprises. That being said, you know, this administration in the United States shares the objectives with the European Union of greater competition in this space, and I think there's a number of, you know, actions being taken through sort of the FTC and our antitrust sort of looking at options. But I wouldn't say that we would be supportive of legislation that only applies to U.S. companies. You of course want to see equity in how regulations are being applied, you know, and where those thresholds are to ensure that, you know, they really are being fair. But yeah.
And this data localization question and the level of protection, well, that goes one way or the other. There was the Microsoft Ireland case, and then there was the Cloud Act in the United States, and now there's pending legislation in Europe regarding investigative orders that is pretty much the same as what you have in Cloud Act. But back to the question, like, is it important about the place of processing of personal data? If I was to answer from my experience, it is more expensive, that's for sure, in terms of compliance expenses. And yeah, so now, Joanna.
Thanks a lot. Well, I think you are certainly right that there are costs involved if you impose this type of requirements. Now, is it something that should be a guiding principle about how to go about localization or not? Well, first thing that has to be said is that the GDPR doesn't impose any localization requirements. It only foresees conditions under which data can be transferred in case there are mechanisms and there are rules for those mechanisms. And if those mechanisms are provided for by the other country, I think there is agreement that there is no problem with transferring data. So I think we have to be very clear about that. And if I remember well, the regulation on transfer on non-personal data strictly forbids localization requirements. So I think we are clear about this. Now, we are very, when I say we, people working on trade, we are very sensitive on that issue, and we have always been scrutinizing each and every piece of legislation that has been developed with regard to the single market through this angle, and made sure that there is precisely no localization requirement because of no clear and good justification to have it done specifically here. So I don't think there are any good reasons to oblige localization. Now, having said that, we are currently discussing with some member state legislation that they have been developing with regard to cybersecurity. And this is a very difficult discussion because as far as principle remains the same, it might not be completely excluded that there might be some cases strictly related to security, to military purposes, where you would find it justified to have a different rule. But that is a very careful and very sensitive discussion. I think this is not something to be definitive at this stage. The one thing I would like to add, this is not related directly to the question, but nevertheless to the SMEs and to the obstacles and whether the law is an obstacle or whether lack of law is an obstacle. I would search for a different type of example compared to what Jaromir said. We have checked the operations of SMEs that are established exclusively online compared to those that function offline. And the conclusion that we draw is that if you have a proper framework for digital trade, it is critically inclusive framework, particularly for small and medium enterprises, because almost 100%, well, 97% of those SMEs that have been functioning online, they have been participating in exports and in external trade. with a very, very small percentage of companies that function exclusively offline being engaged in external trading. So I think that shows the importance of having right regulatory conditions for the companies to function beyond the borders. And conversely, if you localize, if you require establishment, and if you impose restrictions, that basically kills all small businesses. So this is these are our findings. This is how we see and would justify the need to have appropriate rules for data flows.
I think it's very important to mention also this cybersecurity, and there is also defense. And defense is entirely outside of the scope of European Union institutions. And I think that there might be some link between these concerns and like how these cloud services are in general run, because if you have a cloud infrastructure and if it is localized, then it is probably easier to establish dedicated localized infrastructure where you need to have it localized, and that will be defense and at least a part of security. And then it may make sense to have these requirements extended, because then it will motivate the investment that will make then these critical applications maybe cheaper or more efficient. But Javier, what is your point? Back to this question of localization and to this like actual level of protection based on where the data is located.
So, I mean, I think first of all, I want to agree with Anna on what she said about what is and what isn't data localization. We recently wrote a paper mapping different approaches to data localization, and in this debate, it was very clear that there's no actual definition of what data localization is. Some people think that it might be an explicit requirement, and others might think that it's an implicit requirement. The problem with the implicit requirement is that we can put any regulation on there, which might require you to have something locally. So we tracked actually explicit requirements and the reasons behind them. And again, the reasons behind data localization are as varied as the reasons that we have for conditioning the flow of data across international borders. Privacy protection, national security, et cetera, including, of course, also digital protectionism. But as I said earlier, it's these data localization, we need to think about in terms of the different typologies of data localization, because a lot of data localization policies just say you need to have a copy stored domestically, but you can store everything else wherever you want. You just need a local storage here. And I think those are the most benign forms of, like, those don't really cause much harm. Not that they should be justified willy-nilly, but I think that that's one type of consideration we need to think about. The second type of approach is where you require local storage and you set very clearly defined conditions for transfer. Health data is the example of this. You say data has to be stored here. If you want to transfer it, you've got to make sure that when the transfer is made, it meets these types of requirements. The third type of approach is the most egregious one, which is where you impose a localization requirement and you forbid any transfers. And so when we start looking at the evolution of data localization measures, first of all, we see that they are growing, but they're largely growing because of this last third category, which I think in 2021 represent 2/3 of the approaches out of, I think, 92 data localization measures that we analyzed. And what's more surprising is that when we look at the countries that are enacting these, it's non-OECD countries. And so I think that what we need to do in this debate as well is think very carefully about why we're having the data localization, what data localization is being put in place, and who is putting the data localization in place. And that enables us then to make sort of those discussions, whether in the trade world or in other areas. And going back to your question about, who this might impact more or less, I mean, I think it really, really depends on what type of data localization measure they're actually facing.
Mm-hmm. Thank you. And I think that it has even broader context, this localization, and that is with international law and the concept of sovereignty. And now, well, the problem is that now the Russian aggression, it moves us back to like medieval times when the recent concept of sovereignty was established. But the instruments that we have now on both sides of the Atlantic Ocean, like this Cloud Act and now what we are working on in terms of like how to get data for criminal proceedings, etc., I think that it can move us from this very traditional understanding of territory as the basis of everything. Well, we wrote a book about it with Professor Dan Svantesson from Bonn University. It's called Information Sovereignty, and it's precisely about shifting this paradigm. And once we get it moving, then we can discuss. And I think a good role model for it was this Microsoft Ireland case. That was precisely about the question, like, does it matter where the data is physically localized? And the final answer was no, but thanks to the new legislation. And we are moving in that direction also in Europe. So I think that sooner or later this will be shifted, not everywhere, of course, but in many areas. But if I'm correct, then we are slightly moving towards the end of the session, and we shouldn't be late for the wrap-up downstairs. So, yeah, this last question is one last round of answers. It's difficult to ask like one question, but there was one in Slido, and I omitted it intentionally, but now probably I can't help myself but asking it. The question was, basically, should it be the governments who will decide about those policies? Is there enough understanding, or is there enough expertise, or should it be left? And that is, I think I would slightly disagree with what Ruth mentioned regarding the GDPR, because the GDPR is built on performance-based rules, at least in a part. And these rules are different. These rules are something like what we have at home, some of us. Like, I don't know what I want precisely, but if I don't get it, you'll be punished. And you decide how you perform this duty. It creates some kind of uncertainty, but it leaves like relatively broad space for not going in one particular direction, but choosing that direction and how to deliver. Of course, it's not always, and it's not everywhere, especially these restrictions sometimes are strict, but maybe this is the way, like, to leave it open, and not to say like what should be done from the perspective of the government or the lawmakers, but only to say what shouldn't be done. So could this be the approach? Or the basic question was, like, should we expect this expertise to be delivered from the governmental level? Jaromír, you can be critical. You know you don't work for any government or intergovernmental organization. I'm public employee as well, so I have to be careful.
Yeah, okay. I understand what I should deliver now, but really, yeah. It is tough sometimes, very peculiar details, because the government, so when there's restrictions, so the one that writes them, that's okay, because they usually study that quite some time. There's a lot of dialogue around that, or trialogue, or whatever logue there needs to be. But the one that controls it, they tend to be very strict, and they have no, so this is, you know, they're usually the experts on this one paragraph, and they live with it for their whole lives, and it's 2% of your, you know, capacity at the company, and the you know, paragraph experts come and say, how do you do this? And it's really complicated to comply with a lot of detail. So there's it's been said too many times that both, you know, the God and the devil are in the detail. But so that's the problem with enforcing the rules, all the details, and that in that case, that would be really nice, just to have understanding regulations that don't do this and this, and otherwise you're very good to go. It's easy to understand. So the biggest problem, again, I'm speaking on behalf of the SMEs mostly, they have less capacity for that. The more easy to understand the regulation is, the higher you know, probability of full compliance is there. So I'm all for don't do this and that, as long as it's very simple and clear.
Thank you. We can take it from that side.
Well, first of all, one thing I'll say is, you know, these debates are going to continue and only become more important. And I think the fact that we have such a robust audience right after lunch is testament to the fact that these are topics of great interest to everyone. And I think what you asked is a really good question. And I think, one, any regulation really does have to be taken with consulting stakeholders, including businesses, but also civil society and individuals. And I think this idea of sort of should the government say this is what you should do or this is what you shouldn't do? You know, as a consumer, I will say, speaking for myself personally, you know, when I think about, you know, notice and consent, I'm just clicking yes, okay, I agree. The cookies, you know, am I going to take the time and read every cookie? Do I really understand what it means? And frankly, am I even able to opt out, or it just means I don't use that service because I don't think it protects my privacy? But then there's not another model where, you know, pay for service or other things. So I do think more sort of minimum standards, but also consumer choice, I think as a consumer is something that I would like to see. But this is clearly a complicated debate that's going to have to continue, and I appreciate speaking on this panel about it.
That's not an answer, is it?
It's a diplomatic answer.
Javier. Well, Javier can answer from the perspective of intergovernmental organizations, so one level up from the government.
I thought Anna was going to do the answering for all of us. I mean, look, I think I completely agree with what Ruth has said in terms of, you know, you need a combination of approaches. You know, you will need some form of government guidance, which might come in the form of some minimum standards, and you need a sort of the private sector to have that flexibility to be able to adapt their approaches. I mean, we have some of these principles in the trade sphere where we talk about, you know, make sure that regulations are transparent, that they're non-discriminatory, and that they're least trade restrictive. And I think that that's quite useful, because if you're meeting those, then you're probably doing a good job at regulating certain spaces. Perhaps the other area that we have not talked about, which is really important, is, you know, about the technological solutions to the technological problems. And sort of, we always now talk about regulatory ideas, but, you know, privacy enhancing technologies, ISO standards, encryptions, these are all areas where we could make some progress, and not that the problem will go away, but that the problem might be minimized. Perhaps last, just to say that, you know, the positive or the negative list, you know, we deal with this a lot in the trade world, and there are advantages to either, but I would be a bit cautious. I think that, you know, what Ruth was saying, you know, consultation, government guidance, minimum standards in combination is the right approach to continue following.
Right, so I will first say that Javier didn't have to act as blue helmet between the two of us, because we pretty much agreed, but, and I also do not think we are too far apart with regard to the last question, but I would like to say three things. One is that I think this question is valid not just for the digital sphere, it's a general approach to how you legislate. Though there is probably a big difference, which is this is such fast-changing area, the pace of development is so quick that we might simply be behind the curve. So I think that's something to look at while reflecting what is the way to regulate. The second point is related to the very idea, do you regulate ex ante, or if you do not, how do you enforce ex post? And there is a huge difference between the EU and the US, with US much more focus on enforcement, while this is not this very strength of the EU law and the legal system. And the third point, well, we are also regulating for 27 member states. You probably are all familiar with the concept of a directive and a regulation. Directive that sets the framework and lets member states decide about the details. That's what looks very comfortable and very good and very easy, while regulation is prescriptive. We are pretty much regulating through regulations now, legislating through regulations, because that ensures consistency. So I think one should keep in mind that we are not talking here about a given country or a state, we are talking about a community of member states, which does make a big difference. So not that it makes us get closer to the answer, but I think these are elements to consider while deciding what is the right way to regulate. Thanks.
Thank you. Nobody answered my question, but I think that the answer is somewhere there between. I will conclude with personal experience. That was exactly what Ruth mentioned, this approach, like let's talk to the industry and then listen. And lobbying is excellent because you get these different points and then you can sort it out and add some political agenda to it, and then you have the final solution. But this is what the European Commission did when the previous European Commission, when the European Parliament issued a statement regarding artificial intelligence, was asking the European Commission, like, what are you going to do about it? And then the Commission invited these lobbyists, and then everybody was saying the same, and they said exactly the same as Jaromír said. They said, we don't care. At the end, it will be the end user that will pay it. We will sort it out, but we want the regulation to be clear and predictable, and to draw like the environment where we can do business and where we can calculate. which didn't help much, honestly, in designing the actual policy. And the other thing that I would like to conclude with this thought is it's extremely important that we are able to formulate opinions, and these opinions sometimes they can be different, but we speak about the same thing and we are sitting at the same table. And these differences will be there forever. And late Miloš Forman, one of the greatest Czech movie directors, he also won some Oscar. He said, once he was asked about the difference between Czech American movies, he says that European American movies particularly, he said European or American movies, like you always know who is good and who is bad from the beginning, and then there's always happy end, and people leave the theater and everybody's happy and smiling. Like with European movies, you don't know who is good and who is bad even at the end of the movie, and then there is no ending at all, and everybody's leaving the theater confused and depressed. But both types of movies have their place on the market and in cinemas. So let me thank our wonderful panelists, Jaromír, Ruth, Javier, and Joanna, and let's move downstairs for the wrap-up. The minister or deputy minister or somebody very important is waiting there for us. Thank you.